Good afternoon, everybody. Welcome to this breakout session. It's focusing on the future of city land use and its effects on sustainable development. We have three presenters for this afternoon. My name is Robert Kiboke from the University of Nairobi in Kenya. It's good to be back at the Colloquium this year and to see a lot more people. We have three presenters presenting in the order that they are listed. We have Professor Paul Kibble from the School of Law at the University of the Golden Gate in San Francisco. We have Professor Lai Ling Heng from the National University of Singapore. And we have Hendrik Schukens from Ghent University in Belgium. So each of the presenters will get 20 minutes to make their presentation. And I think we'll just do 3 consecutive presentations and then we'll take questions and have a discussion at the end of it all. The presenters get 20 minutes. The timekeeper is strategically positioned with very threateningly colored notices in red and other such colors. So we now give the floor to Paul Kibble, and he'll be speaking to us about a remedy for fragmented urban open space, the Hanover Principles on Land Use. Thank you.
It's Kybell, but I'm used to it. Okay, so in the 1960s and 70s, just to sort of get us focused in on some of these urban issues, a lot of urban planning efforts reflected a very sharp dichotomy between the conception of nature and the conception of cities, with the notion that nature was something that happened outside of cities, and that the main purpose of cities was often to provide increasing density for good reasons, perhaps related to concerns about sprawl. But within this concept, nature was understood as something that existed outside rather than within cities. There was another line of thinking, however, that began to develop more in the 70s and 80s that rejected this sort of cities-nature dichotomy. Author Anne Whiston-Spring wrote a book in 1984 called The Granite Garden, Urban Nature and Human Design. I still recommend it. In which she wrote, quote, "The belief that the city is an entity apart from nature and even antithetical to it has dominated the way in which the city is perceived and continues to affect how it is built. The city must be recognized as part of nature and designed accordingly." In her book, Whiston-Spring further elaborated, "The more a park resembles a natural ecosystem, the more easily it can be managed as a relatively closed system. Parts of large parks, leftover land on steep slopes or along floodplains, and even weedy vacant lots can all be designed as self-maintaining and self-regenerating systems." In her book, The Granite Garden, she also emphasized the important habitat roles that urban woodlands and urban waterways can play in regional ecosystems. So many of the land use ideas that were outlined first by Whiston-Spring in 1984 in The Granite Garden were later reflected in something called the Hanover Principles on Design and Sustainability. And the Hanover Principles were developed during the 1990s as a run-up to the Hanover World's Fair in 2000, which was held in Hanover, Germany. The focus initially was really to provide guidance on how they were going to set up the fair in terms of facilities and buildings. But there was a large component of the Hanover Principles that dealt with land use issues, and in particular with concerns about fragmentation, both of open space and habitat. Some of these ideas, just picking up on the presentation this morning by Amy Frankel, United Nations, coming out of Rio 20, has also adopted a Sustainable Cities Initiative, which has a very strong habitat component as well. So we see sort of a trajectory here with some of these ideas being incorporated. For my presentation today, I wanted to take some of these land use and open space concepts in the Hanover Principles, which are somewhat abstract, and to really drill down and situate them for you in a very concrete and a very real and a very geographically specific place. I serve as co-director of the Center on Urban Environmental Law, CUEL, at Golden Gate University School of Law in San Francisco. And for the past 2 years, one of CUEL's projects, which has been under our Green Space program, has been conducting independent research on land use and open space issues related to an area which is the former Alameda Naval Air Station. It's an area that's now known as Alameda Point. And Alameda Point is located in Alameda, which is an island city just off the shoreline of Oakland, California. And what we have found is that in our work around Alameda Point and open space issues, the Hanover principles have proven very useful in a number of ways. They've been useful in sort of conceptualizing what the site might be from its current condition. But they've also proven very helpful, and this is what I think might be interesting to the rest of you, in helping sort of shape and frame advocacy strategies about how we articulate what we're trying to do. So that's what I'm going to be covering today. All right, so far so good. So for those of you who may be less familiar with the San Francisco Bay Area, I'm hoping this aerial photograph will help to situate you. If you view the San Francisco Bay as sort of a circle, you have the North Bay, you have the South Bay, you have, from where you're looking, the West Bay and the East Bay. West Bay, you have San Francisco. South Bay, you have San Jose. North Bay is Marin County with some cities like Tiburon and Sausalito. And in the East Bay, you have a number of cities as well, such as Oakland, such as Berkeley, such as Richmond, and the city of Alameda. And Alameda Point is located within the city of Alameda. The photograph that you're looking essentially westward, straight down what's called the Oakland-Alameda Estuary. And to your right, you see the city of Oakland, primarily a lot of the cranes of the Port of Oakland. And to your left, you're looking at the city/island of Alameda. And on the very tip out there, where you see that sort of trapezoidal development, that and the buildings adjacent to it, that sort of square out there, are what is Alameda Point. And beyond it, San Francisco Bay, Bay Bridge, San Francisco skyline. So as I mentioned, Alameda Point is the new term for what was previously the Alameda Naval Air Station, which stopped operations. The base essentially closed in the early 1990s. And there are two very distinct portions or segments of Alameda Point, and you can see them somewhat from this picture. On the west end of Alameda Point are the unbuilt portions, and this is where the former jet tarmac and runways were located for the Navy planes. These unbuilt portions are about 700 acres, and they are still owned right now by the federal government through the Department of the Navy, which is a sub-agency of the Department of Defense. On the west end of Alameda Point, we have the built portions of the former Naval Air Station, which are administrative buildings, airplane hangars, and some military housing. This is about 400 acres. So all told, we're talking about 1,100 acres out there. And in 2010, ownership of the built portions of Alameda Point was transferred from the Navy to the city of Alameda, and the city of Alameda is now going through its own elaborate land use planning process to decide how to sort of repurpose, redevelop, conserve, what is it going to do with this land. So to help ground my comments today, which is sort of taking this idea of the Hanover principles and placing them in a real place, I wanted to provide you with a sense of some of the natural resources and the scenery and the wildlife that are out there at Alameda Point. And the best way I think to do this, rather than have me talk about it, this is, we'll see if this works. One more? Here. About a year ago, I'm going to show you this video called Alameda Point Land of Open Space, which was produced by people affiliated with a group called Alameda Point Environmental Report. And it's on our website. as you sort of get a sense, and you can see it from this map as well, you know, for a very urbanized area like the Bay Area, having 700 acres of undeveloped, unbuilt land with those types of views and resources surrounded on the San Francisco Bay by 3 sites is a really remarkable green space opportunity. The video gives you some sense in terms of, you know, what you probably saw from the video is that birds are very much front and center out there. And there is a sandy portion of Alameda Point where you saw those little houses, which actually National Audubon has been helping with. That is an area that serves as a colony for the rare California least tern, which is listed as endangered under both California and the Federal Endangered Species Act. And since the planes have stopped flying there, it's been a very successful colony of terns. But there's also extensive wetlands throughout the site, both freshwater wetlands that are wholly contained within the site, and also some brackish and saltwater wetlands that are hydrologically connected to the bay that serve as important habitat for a lot of migratory waterfowl, including geese, ducks, and herons, some of which like the tern eggs, so there's some interesting Audubon issues there, but I won't get into that. So, as I said, it's a very rich place. So in terms of the Hanover Principles, the actual document that was produced for the Hanover Fair is about 60 or 70 pages long, so I'm not going to be able to give you a comprehensive overview of it, although it's definitely worth reading. Rather, what I wanted to focus in on are two particular principles or concepts that came out of the Hanover Principles that have been particularly pertinent and helpful to our work at Alameda Point. And these two concepts relate to respecting natural borders and to humility in design. And I'll sort of unpack those two for you. So first, you know, unlike many more rural areas where it might be more common to have one agency or one large ranch owner with ownership intact, it's much more common in urban situations to have multiple landowners and even multiple agencies with oversight over different open space lands. It's simply the reality of it. And one of the things that the Hanover Principles cautioned against was trying too much to focus on planning within jurisdictional boundaries. What they suggested is let your starting point be the natural boundaries of the land, whether that be habitat corridors, whether that be scenic or view sheds, and then figure out how you need to work with the different landowners or with the different agencies that have jurisdiction to come up with open space and land use planning that sort of respects the natural boundaries, whether they're view sheds or habitat of the land. So that was the first aspect that struck us as particularly relevant to what we were dealing with out there, particularly with this split jurisdiction going on between the federal government on the unbuilt portions and the city government planning process that was sort of beginning to unfold on the city portions. The second concept of humility in design, much of urban space, often because it's somewhat compact, tends to be heavily landscaped and micro-designed, often with recreational uses in mind. And that's understandable, but the Hanover Principles, once again, cautioned against this. They cautioned against it for a couple reasons. One, in terms of providing habitat or ecological or ecosystem services, a heavily landscaped type use of open space is not going to have as much value. I'll try to move through it. As non-landscape land. The other is that these more naturalistic spaces, if they're allowed sufficient latitude, tend to be more self-regulating and actually reduce costs over time. If you set up a system where the different plants and species can sort of balance themselves out, that they're not micromanaged, they tend to find an equilibrium. So time is short, so what I'm going to do is talk about a couple different ways, and maybe you'll indulge me 2 extra minutes, I think you can, to talk on a practical level about how these ideas were translated at Alameda Point. So the first thing I'll talk about is this concept of flight park. We realized as we started working on these issues that there wasn't really a good language to talk about what we were doing. The federal government was very focused on what was going on with its portion, the city was focused on its portion, and no one was really seeing the broader opportunities across the jurisdictional space. We published a report in September 2011 called Flight Park at Alameda Point. in which we said, for a minute, let's stop talking about the federal portions and let's stop talking about the city portions, and let's just imagine what this space could look like if it was properly oriented, if it was properly developed. What we have found is the mere development of that idea, and the idea with Flight Park had to do with the fact that one, former Navy uses, a little bit of homage to the former Navy uses, but given the birds and the wildlife out there, it seemed to make sense on a lot of levels. But what we found is actually this, having a word to talk about what the Hanover principles are has proven very helpful, and I can give you a concrete example. There's a local park agency, the East Bay Regional Park District, that has expressed interest to both the Navy and the city in taking on a larger role in managing these types of lands. The Park District, in its approach to the city, has actually cited Flight Park as a concept for why it makes sense to look at these sites together rather than separately and to manage them that way. Second thing I'll mention, concrete situation. If you look at, that's a tarmac out there, and about halfway between, there's been negotiations between the Navy and the Veterans Administration, the VA, which is a federal agency, over siting a medical outpatient facility, sort of in the middle of the open space expanses. And there are a lot of environmental concerns related to this. The concerns are not so much related to the footprint of the facility, which is about 20 acres, not massive, but there's going to be an access road out to it, and it's estimated that it would have about 1,500 vehicular trips a day. So in terms of traffic, noise, effects on wilderness, wildlife, exhaust, there's a lot of fragmentation of habitat and scenery that would occur as a result of this. We have been advocating with other stakeholders for consideration of an alternative site, which is down here. This site had been looked to for a possible University of California at Berkeley laboratory, but Alameda lost that bid to a different city, so this space has now become available. So we are saying, listen, if you site the VA facility in this other area, there's an alternative site that's available to avoid a lot of the habitat and scenic fragmentation that would result from this. And we've been using a lot of the language of the Hanover principles in terms of trying to articulate. I mean, ultimately, there may be NEPA litigation that's going to be required to force consideration of this alternative, but I don't need to get into that right now. Okay, two more examples, and then I'll move towards the end. While the discussions over this proposed Veterans Administration facility were going on, the Navy was proposing remedies for its environmental cleanup. It would use certain of these areas for dumping some of its materials it would use. In particular, this area out here, which is one of the most scenic areas, is known as Site 2. And just 2 months ago, the Navy proposed its permanent cleanup remedies for that area. The permanent cleanup remedies proposed by the Navy were to put a 6-foot-high chain link exclusionary fence with 3 feet of barbed wire on top of it around the fence, around the area, to keep people out, because that was what they proposed. They also wanted to put a network of about 50 10-foot-high methane gas fence throughout the scenery. So we're looking at this as scenic open space that hopefully would have appropriate access to the public. Nothing could be more inconsistent than that. So we have been jumping in, once again, using the language of the Hanover principles to say, listen, there are a lot of other sort of landfill and open space projects that don't have this type of fencing, that don't have these types of visual obstructions, and we've been pressuring the environmental regulators who need to approve this to take a hard line with the Navy and say that they need to come back and look at other alternatives. It appears that we have made some headway in that regard. We got a letter out of the California Regional Water Board 2 weeks ago saying that given the planned open space uses, the Navy really needed to go back and look at alternatives to this. Okay, the last thing I'll mention, and then I'm done, is as the city's going through its planning process here, this is an area called Seaplane Lagoon. The city had initially began talking about having development go smack up to the lagoon with like a 20-foot walkway along it. And we've been saying, why don't you push this back 300 or 400 feet, have a beautiful bank of grasslands there. One, we think there are reasons why that will actually make the place more attractive. This is a report that we did that gives you a sense of what it would look like. But one of the other reasons is that by having this bank of grasslands there, you're going to develop both scenic and habitat corridor links to the federal land that's out there. It's going to draw people in. That's the idea. So once again, I'm just giving you some concrete examples in this particular location of how we're using these notions of humility in design, more naturalist landscapes, and trying to look beyond traditional jurisdictional boundaries to get them to think more holistically about it. So I think I'm out of time, right? Probably more than that. And I guess I'll take questions at the end. Thanks.
And now we have Professor Liza Heng presenting on environmental governance and management, the need for environmental management systems for cities. So you also get 20 minutes.
While we're waiting for the PowerPoint presentation, yes, thank you very much. Basically, my presentation, let's hope I can do it in 20 minutes, is, oh dear. Okay, I'll just press this instead of that. Okay. Right. And those of you who were present at one of the sessions this morning that session discussed what constitutes sustainable global environmental governance. I'm going to narrow it down to looking at basically governance of a city, environmental governance at a city level. And we all know cities have large environmental footprints, and there are always the tensions between development and conservation. And one of the main problems is that cities are getting bigger. People are going to the cities all the time. So how are you going to cope with the increased population on limited resources? And the other problem about cities is there's a lot of pollution going there because of the economic development. Industrialization seems to be the way to go. So what are the solutions? And what is the role of the law here? So, at the same time, we have to be aware that there are advantages to cities. The concentration of industries and population brings some advantages as well as savings. From the economic viewpoint, you have lower costs per household or enterprise because of the number of people and enterprises. They share the environmental infrastructure. And this also leads to greater efficiency in the enforcement of the laws. Everything is closer. They don't have to go so far out into the countryside. Cities with good public transportation systems reduce the need for private motor vehicles. And you can see in the big cities, London, Hong Kong, New York, very few people own their cars. Or even if they own, they only use it in the weekends because public transportation is so efficient, right? So at the same time, you can have better educational facilities, everything is close together, better recreational facilities. So there are advantages to being in a city. But the challenges of cities are very obvious, of course, providing the citizens with a safe and reliable supply of food, water, and essential services, coupled with the tensions of increased population. So basically, I think we can agree here that there's a need for good roads and efficient public transportation systems, modern sanitation, effective waste management, decent and affordable housing. And here it's very important to emphasize on the housing, because when we talk about developing countries, they do not have adequate modern sanitation, and that contributes to the water pollution problems, etc. So once you've got good housing, that solves a lot of the problems, and that goes into building of the environmental infrastructure. You need good communication facilities, and if you have that, then you reduce the need to travel, right? So at the same time, we have to ensure that our citizens in the city get a good quality of life. This means that you have to think about parks, recreational facilities, playgrounds, even shopping malls. Now, what is really lacking in many cities is the protection of the natural and, to a lesser extent, the cultural heritage. Cities just happen to grow up that way, knocking away all the trees, in the process of development. We need to bring back the natural environment into our cities. And of course, we need to rethink how we use our natural resources to ensure that our development is sustainable. Now, the solutions will differ depending on the resources and the needs of each city. The needs of the developing world are very stark. You have the urban poor. They lack infrastructure. They have poor transportation systems, lots of squatter colonies, inadequate housing, public health problems, etc. You have a lot of pollution, a lot of noise, pollution of the air, the water, etc. They don't know what to do with their waste. And the major problems with toxic waste, loss of natural areas that I've mentioned, loss of heritage. Not many cities appreciate their built heritage. In Singapore, we destroyed a lot of our built heritage. So of course, there's a lack of institutional capacity, lack of financial capacity, wrong policies, lack of political will, corruption, cronyism. All these are present, right? Some are present also in developed cities. One of the best examples, I think, is a study in Bangalore, but I don't have much time. Very poor, inefficient legal system, confusion between government institutions, fragmented actions, etc. Poor environmental infrastructure, laws that are woefully inadequate, and of course, the interference of politicians in bureaucratic decisions, corruption and cronyism, etc., right? So if I may quote a judge, he said, "The order of decisions is all wrong. Politicians decide on the projects, and then the scientists simply concur. It should be the other way around, but no one has the guts to make an independent decision." So nothing has improved in Bangalore. It's one of the most polluted cities in India. So what is needed in Bangalore is an EMS, an environmental management system. Now you've all heard of ISO 14000, but you probably do not know that well, I wouldn't say many, there are cities that have got ISO 14000 certified, right? So that's what we're going to look at. I will skip this. We all know what the ideal world ought to be, okay? What is sustainable production and livelihood? What is the green economy? So let's look at ISO 14000. We all know about ISO 14000. And basically, this is a series of international standards developed by ISO in Switzerland. And basically, for the 1400 series, this is targeted at corporations and organizations, particularly business and industry, to manage their impacts on the environment. But if you look at it, it is basically an environmental management system. And it can work in many organizations, in a city, in a municipality, even in a village. If you look at it, we have, in fact, been implementing an EMS system, right? It's just that it has not been analyzed as such. So basically, the concept of ISO 14000, you plan, you do, you check, and you act, right? And in fact, in 2003, UNEP commissioned a study on EMS, which is Environmental Management Systems, and ISO 14000 for cities. And it used Tokyo as an illustration, and it produced a toolkit. Now, here's the surprising thing. In the US, Denver is ISO 14000 certified, okay? And they have a nice website, and basically they tell you all these things. It's what they've been doing. There are other cities. There's Dallas, there's Seattle, Charlottesville. In Canada, there's Toronto and Edmonton, and there are quite a number in Japan that have got ISO 14000 certified. But basically, every city, every town, every municipality down to every village needs an environmental management system. So, what is required in an EMS? As I've said, it depends on each city, what its needs are, what are the priorities. I would suggest that you need to start first with the institutional and administrative structures. You need to see that your institutions are working properly, right? Your ministries, Ministry of Environment, Ministry of Forestry, whatever, they have to be carefully conceptualized and they have to work together. You need definitely comprehensive land use planning laws and policies. Now, with regard to environmental laws, you can have the best environmental laws and they're not going to work unless it's integrated with the environmental management system, okay? You need good housing, right? With modern sanitation, provision of water. You need the physical infrastructure for the essential services. clean water, energy, transport, communications. In fact, I call this your environmental infrastructure. If you can have the best water pollution laws, if you don't have a good sanitary system, good public sanitation system, sewage treatment plants, it's not going to work. So you have to spend money on building your environmental infrastructure. So you need to look at, the other parts, the collection of your garbage, treatment of your hazardous substances, etc. So all these are part of your environmental management system. So laws are only a part of the system. It's not going to work. You do have to spend money on building the physical infrastructure. So the next question is, where is this money coming from, right? Right. So now we have a quick look at building your institutional capacity. Which institutional structure is best? You need the Ministry of Environment. How about the Ministry of Environment and Natural Resources? Because the Ministry of Environment, taking Singapore as an example, we have the Ministry of Environment and they're only blinkered looking at pollution, because we have another ministry in charge of nature conservation, and sometimes they don't gel. Okay? So you have to think, each system has to think which is the best. Then these institutions have to work together. Frequently they overlap. Now in Singapore, actually we work quite well, because the first part is deciding what industry to bring into Singapore. There are many places in the world where there's no coordination. And I know in one of the workshops that we ran, and a participant from India said that there was no system in India. He's from the Ministry of Environment, and suddenly the Ministry of Finance tell him that there's this new industry that's coming in to set up. And they just can't cope with the pollution, but nobody consults them. So this is a very major hiccup. And it's very important that the industries and the ministries have to work together, right? So then you have your financial considerations. How do you bring in investors but at the same time the right type of industries that you can cope with? And you need your education and training of your personnel, etc. Even in your technical assistance and economic aid, you must ensure coordination. And here I'll give you another example. In the training program, again, another training program, we had a chap from Vietnam, and he said, we've just beefed up our law on water pollution. They say it's useless. We got some grant, and an expert, a lawyer from Western jurisdiction came and basically gave us their laws. But it's useless, he said, because we don't even have the laboratories to test for the trade effluent, to test the water quality. So what's the point? So the point is that there are other agencies that's going to give you this money. If you had a coordinated approach, you would have asked for these two things. Yeah, we want the lawyers to give us this law. At the same time, we want the money to build this infrastructure, to implement and enforce the laws. So there's no coordination, right, in many places. So it's part of the EMS. You need to coordinate. Now, I can't emphasize how important sound land use planning is, because you need to ensure that your industries are sited far away from your residential and commercial areas, and you need to fine-tune the industries. The more polluted the industries are, they have to go further away. And what is even better, there's this new concept now called industrial ecology, where the waste from one industry can be used as the raw materials for another industry. So good strategic and sound use planning, land use planning, will make full use of this, right? So we need to rethink how we're going to do that. At the same time, you need strategic land use planning. You need to plan for the future, anticipating the future growth. You need to project your land needs for the infrastructure, transportation, sewage, waste dumps, etc. New residential and commercial industrial sites, water catchments. Yet at the same time, you need to look at what you have, the restoration and rejuvenation of your city, the conservation, etc. So there are lots of things that you need to work out very carefully in your land use planning. So this is part of your EMS. Right, I can skip this, except to emphasize that, again, you need to look after your natural environment. And of course, in this process, you need to involve the public in accordance with the aims of Agenda 21. You need EIA laws, etc. Then we come to the laws, environmental laws. You need to identify the laws that you need. Existing laws need to be analyzed. What are their strengths and weaknesses? If they are no good, you have to change them, right? Who administers, who implements and enforces? Ideally, you should start with constitutional provisions, but that's not the way most countries have developed. Principles developed at Rio ideally should be in. And also, hard and soft laws, codes of practice, administrative codes, these are also useful. I think we also need to bring in economic incentives and disincentives, and now these are viewed upon as aspects of environmental taxation. We need environmental audits and monitoring, public access to information, public participation, access to courts. Then we need to look again more closely at our laws. Are the penalties realistic? How about reversing the onus of proof? And in the context of a country, if, for example, we keep increasing the penalties, when the country is corrupt, you might just make the inspector a wealthy man. So that may not help. So you might need to think of other strategies. For example, in Indonesia, they came up with a name and shame program to clean up their rivers, the proper Prokasi program. I have no time to talk about that, but maybe you can ask me some questions later on. In Singapore, we have very good anti-litter laws. And one of the things we've done is name and shame. We have something called the corrective work order. You have to wear a bright yellow vest that says corrective work order, and you have to clean up a public place in full view of everybody. Okay? So again, in Singapore, we also have reversed the onus of proof. Right. So to make law enforcement easier. And many countries have jail sentences for the corporate officers, right? So then the next question is, how to find the money, right? And it's of course more complicated when you have a big country and different levels of government and political interference, etc. But at the heart of this really is, if you have respect for the rule of law, you can find the money. You can borrow it from the World Bank, you can borrow it from the Asian Development Bank, and on top of that, there are companies that make this their business to invest in environmental infrastructure. Credit des Eaux, for example, 100 years, Thames Water, they spent all their experience, making good systems for the provision of water. They will only come to a country where they know there's respect for the rule of law, because they know that at the end of it, they're going to get back their investment. So again, the law is important here, and it can work. Okay, and you can do it in different ways. There are different types of contracts that these people would be prepared to go into. Okay, so finally, I'm to wrap up with something that Singapore has proposed, which is a biodiversity index for cities. Singapore realized that many cities are just concrete jungles. They have, knocked down every tree, every blade of grass. There's a need to bring it back. So in May 2008, our Minister for National Development, that's the minister that's in charge of greenery, proposed that the parties collaborate in developing a CBD, there's a Convention on Biodiversity, Cities Biodiversity Index. And we actually thought through the whole thing, experts in the nature ministry. And it was endorsed in Nagoya at the 10th COP 2 years ago. And basically, there are three components for this index. You look at what's the native biodiversity in your city, what are the ecosystem services provided by the native biodiversity, and then you look at how to properly govern and manage these. So if you look at the CBD, you can actually find details on the Singapore cities biodiversity index and how to implement this. Okay? So in conclusion, I'd like to emphasize, therefore, that every country, city, province, municipality, or village needs an EMS, an environmental management system. And an effective EMS is an excellent step towards sustainability and sustainable development. It is really part of good governance and management. And laws are only a part of the EMS, and the best laws will not work without the EMS, without sound EMS. So good governance requires good government. You need the right policies, you need your laws, you need well-educated civil servants, you need political will, and you need a clean government, ideally. So these are the challenges in relation to governance systems and politics. So here's a picture of Singapore. If you look at the river, it's not very clear, because you know the slides. Anyway, this is where it all began. We were a British colony, started in 1819, a very short history. When the British left us shortly after the war, we were very, very, very poor. We begged them not to leave us because we needed their jobs, but they were in bad shape after the Second World War, so they said, sorry blokes, we have to leave. So we were fortunate to have very good government. And our Prime Minister, our first Prime Minister, wrote a book subsequently, and the title of his book is From Third World to First. The Story of Singapore, 1965 to 2000. 1965 was when we left Malaysia. It was a very unhappy marriage, so we were thrown out, got a divorce. And then from that period onwards, we actually went from third world to first in 30 to 40 years. And I would like to say that there is a good environmental management system in Singapore. We could do better, but I think we do have a sound EMS in place. Thank you very much.
Well, for those of us who grew up or work in the developing world, I think this is a very popularly used analogy of how many countries were together with Singapore and South Korea in 1965 and the difference in today. I'd like to introduce Henrik Schukens, who will speak about the integration of European air quality standards in spatial planning, new avenues for a more sustainable urban planning. He too gets 20 minutes to tell us something about that.
Thank you very much. My name is indeed Henrik Schukens. I work as a PhD assistant at the University of Ghent in Belgium. I'm going to talk about the integration of air quality standards in spatial planning within the European Union. And I will do this by analyzing a case study about the construction of a new road in the urban area of Ghent. So, my presentation will be divided in 4 main parts, which could be boiled down into on 4 main questions. Why all the fuss about air quality nowadays? Second question would then be, what is the law in the European Union? How does it work? And how do we have to apply this law to a spatial planning context? So first, let's talk numbers with respect to air quality. If we would do that within the European context, a good starting point would be the report of the Environmental Agency, the European Union, of 2011. And it has some mixed conclusions. On the one hand, there is a decrease in the emissions of main air pollutants, but on the other hand, there is an increase of atmospheric concentrations for, amongst others, particulate matter. Today I will focus on the issue of particulate matter. Why? It's quite obvious, because one of the most striking conclusions of the report I just mentioned is that 20% of the EU urban population lives in areas where the daily limit values for particulate matter are not met. And if one would take into account the guidelines from the World Health Organization, numbers would even be higher. So this is a map of the European Union. All the red areas are the areas where the limit values for particulate matter are not met. So as I am from the Flemish region, I will indicate it. It's here. It's also a red area. It's located within one of the most polluted areas in the western part of Europe. It also makes clear that many member states are having problems with meeting their limit values for particulate matter. This is a map of the Flemish region more in detail. So also here you see that The red spots are closely linked, of course, to the main urban areas in Flemish region. Here you have Antwerp, Ghent, Bruges, Kortrijk. So, particulate matter, I used the term already several times. What is it? In fact, it's a blanket term for all tiny particles of dust which one can find in the air. And in legislation, in science, one makes a distinction between PM10, which are particles which have a diameter between 2.5 and 10 micrometer, and the more finer particles, such as, for instance, PM2.5. So here you have, in order to visualize the tiny size of particulate matter, this is fine beach sand, this is human hair, and there you have particulate matter 10, and the more smaller parts, this is particulate matter 2.5. So very small, even not detectable with the human eye. So particulate matter, some words about the origins of it. It is either from natural origin or from, and is emitted by anthropogenic sources. The main sources are traffic, energy industries, and the agriculture. But it's important to note that traffic, especially within urban areas, as you all would expect, is one of the most important sources of the emissions of particulate matter. And one has investigated this issue more in detail in the city of Ghent, which will be the subject of my case study, and there it is estimated at around 40 to 20% of the share is, so its share of up to 20% of the total of emissions of particulate matter. Here we have an overview of the main shares. So conclusion is energy industry, agriculture and traffic are the main sources for particulate matter within the European Union. So I'm going to talk about the Flemish context in my case study, so it's important to know some features of it. It is still one of the most dirtiest places with respect to air quality in the European Union. This is specifically the case because notwithstanding the reductions in emissions of secondary particulate matter, that is particulate matter that is created through chemical reactions within the air, the emissions of primary particulate matter, which is created, for instance, by direct emissions of traffic, has not been reduced much. So, on the other hand, one states that, yeah, but most part of these emissions in the Flemish region, which are monitored, they originate from abroad. This is true. 30 and up to 40% of the emissions can be allocated to the neighboring countries. Yet, on the other hand, Flemish region is also a main exporter of particulate matter. So, in any case, we do have a serious problem. And we do have a problem specifically because medical studies show us that particulate matter is the most, has been attributed the most severe health effects from all of the air pollution area. So there are no safe levels which have yet been identified. However, there are of course some legal standards, and I will come back to this later. In essence, it comes down to this: the more smaller the particles can be, the more dangerous they are. And this is quite logical, as you see on this slide. They can enter our body and they can enter our lung system. The bigger particles, they get eliminated through coughing or sneezing, but the smaller particles can get deep into our respiratory system, so they can cause serious health effects. And here you can see a map of Europe. It's a bit outdated, but still it shows the loss in statistical life expectancy, which can be attributed to particulate matter exceedances. And you also see here that the Flemish region, country of Belgium, is one of the most affected areas. So now some brief words about the legal framework. You have, within the European Union, you have these European directives, you have the international conventions, and you have national legislation. I'm going to talk briefly about European directives, as most of the national legislation is just mainly about implementing these European directives. Most important directive is a directive of the year 2008, which sets rules on the ambient air concentrations of main pollutants, such as particulate matter. It is quite a recent directive. It only had to be implemented in the year 2010. However, there were already some existing directives with respect to this topic. but they were all merged into this one big framework directive. It's also important to know that this new directive also for the first time will impose limit values for particulate matter 2.5. That is the smaller particles of particulate matter. So this is quite a big change, but they will only enter into force in the year 2015. It's important to know that within this directive you have air quality standards. So I mentioned already the standard for PM 2.5. They will enter into force in 2015. But there are already existing air quality standards. These are the standards for PM 10. And you do have two limit values. And it is the first one, the 24 hours limit value, which is the most difficult to attain. In many places in the European Union, this limit value, which states that 1 cubic meter of air can only contain 50 micrograms of particulate matter 10, and this can be exceeded only on 35 days a year. But for instance, in the Ghent area or in the city of Antwerp, this limit value is being exceeded, and you have numbers like 50, 60 days a year. This limit value, this daily limit value, is being exceeded. So we know now the standards. What does the directive say with respect to the ways how to get there? It just states that, yeah, well, member states, you have to adopt air quality plans, you have to adopt measures. So there is a wide discretion. There is no clear link there between spatial planning, spatial projects, and air quality. It's not like, for instance, in the Nature Conservation Directive, you have a specific clause, like is also present in the Endangered Species Act, I guess, which states that whenever you have projects which can have an impact on nature objectives, you have an assessment. But this is not the case in the European Air Quality Directive. It's important to know that there is also a second directive which is relevant, and this is the so-called NEC directive. It sets ceilings for member states with respect to the emissions of four main pollutants, such as sulfur dioxide. But also here, there's not so much guidance. The directive just states, well, it's up to the member state, you have to adopt measures in order to attain these ceilings. So also here, a wide discretion. So this, in order to end our journey through the regulatory framework, I also have to mention that, of course, there are also rules on the emissions by cars in the European Union, and you have also a specific directive which deals with industrial installations. So now you have the broad overview of the legislative framework within the European Union with respect to combating air pollution. So now we're going to apply this to a specific case. The case is about the construction of the case that I'm gonna handle is called the Ghent-St. Peter's case. In essence, it deals with the renewal of this railway station. So here you have the railway station. It's going to be renewed. Yet the city of Ghent and also the Flemish authorities decided to add some additional spatial projects to this renewal operation. Here you have the housing blocks, you have new offices, but they also decided to construct a car park for no less than 3,000 cars. And in order to get the cars to the car park, a new road had to be constructed here through the area, through the neighborhoods of the railway station. So as there are many people living in this immediate surroundings of the railway station, they were of course not against the renewal of the railway station, but they were against this construction of this new road, because in the environmental impact assessments, it was already assessed that limit values were difficult to meet in the area, and with the construction of this new road, the new traffic, this would even be harder. Here you have another picture from a different angle of the project of the railway station. So the main argument in legal terms was, well, yeah, you have these limit values which are included in the European directive. You have to respect them when you issue a building permit, when you decide upon a spatial zoning plan. These are obligations of results according to the Court of Justice of the European Union, so you have to respect them. And this reasoning was a bit inspired on some Dutch case law, in which at that time these air quality directives caused a lot of unrest because they were being applied very strictly by the Dutch courts and caused many delays for many spatial projects within the Netherlands. So in essence, it came down to a battle between two approaches. You had the so-called Dutch approach that states, well, yeah, you have to respect these limit values, they have to be applied very strictly, also within the spatial planning context. And then on the other hand, you have the moderate approach, which just states there is no direct link between air quality and spatial planning. These obligations which are included in the directive are very wide and open, and they just allow a wide discretion to the member states. You just have to draw up your action plans, foresee some measures, and then everything is okay. So there is no direct link between spatial projects and air quality objectives. So the Belgian Council of State had to decide which approach would win. And it could not rely on case law from the European Court of Justice because it's a European rule, but there was no case law present yet at that time. So first outcome was a provisional outcome. So the inhabitants asked for the suspension, but the Council of State stated, no, we're not going to suspend the building permits, we're not going to suspend the zoning plan. Because, according to our opinion, this air quality directive, it contains no specific clause with respect to spatial projects, so there is no link, so the project can go ahead. The only thing member states have to do is to draw up these action plans with some general measures, but as far as as far as the Council of State is concerned, there were action plans present, so there was no direct link between spatial planning and air quality. Yet these inhabitants, they wanted also a decision on the merits of the case, so they decided to continue the proceedings. But in the meantime, some major developments took place, amongst others in the Netherlands, which could have an influence on the final outcome of this case. First, it's important to spend some time on the evolution in the Netherlands. So the Netherlands, they had the strict case law, which was different from the approach of our Belgian Council of State. In the Netherlands, it was, but then in the Netherlands they stated, well, yeah, we are the only country in the European Union that applies these air quality limit values to spatial projects. So they decided, well, we're going to make our law more flexible, because it appears to be that we are the only country, so it doesn't seem necessary, we are applying the rules too strict. So they decided to change their law. So this is also an important evolution because it shows the way our member states were applying those air quality standards to spatial projects. Even more important was a reply from the European Commission to a complaint that had been brought forward by these inhabitants. So these inhabitants had not only started legal proceedings in the national courts, they also went to the European Commission, but the European Commission just agreed with the reasoning of the Belgian Council of State. It only stated, well, yeah, this air quality directive, it gives this discretion to the member states, and as long as we don't conclude that these measures are inadequate, everything is okay for the member state. But it adds the following, it states, well, whenever we should conclude that these measures are inadequate, then the project still would have to be stopped. And this happened only a few months after, because Flemish region had asked for a time extension for the application of these limit values. But then again, the Commission stated, well, yeah, we're going to look into your measures, but we're not satisfied by your measures. So the European Commission started an infringement action against the Flemish region for not respecting this air quality directive. So one would expect that the Belgian Council of State, while thinking about the case, would perhaps go to another decision. This happened in a way, but not that much, not in the sense that it finally annulled the decision. It just stated, again, there is no direct link, yet there could be a direct link. So, but in the end, this was not proven in this case, so the building permit and the zoning plan was not annulled in this case. However, two main corrections were made by the Council of State. It stated, well, whenever you can prove that these programs are not adequate enough, you as an inhabitant of an area where the limit values are not met can go to a civil court and ask for the adoption of additional measures. But this has no relevance for the building permit, it just is another legal proceeding, but you can do this, you have this right, and this also had been already decided by the European Court of Justice. And it stated, secondly, that okay, whenever you can prove that this one project would clearly go against a national program with respect to air quality, if you can prove this, then the air quality directive still would be violated. But this is such a high burden of proof, because then you have to prove that this one project is really really will make unfeasible the whole national programs with respect to air quality. This is such a high burden of proof that this was not easy to be met, and as such it was also not met in this case. So one could criticize this approach from the Belgian Council of State from the point of view of sustainable development. However, from a legal point of view, it has to be noted that it is in line with a recent decision of the European Court of Justice that stated, well, also with respect to another air quality directive, that whenever you have ceilings and whenever you have air quality standards, that there has to be no direct link between those ceilings and these air quality standards and the granting of a specific permit for a specific source. So in this, to finalize my case study, I enlisted the pros and the contras of this reasoning of the Belgian Council of State. Of course, there are some advantages to this approach, because you don't have any unnecessary administrative burdens for spatial planning projects. Secondly, it also seems to be, from a legal point of view, in accordance with the wordings of these directives, and also in accordance with the case law of the Court of Justice. And it also appears to be more sensible to go for a more global approach. For instance, like the previous speaker noted, a more ecosystem management approach than for the whole city than to go for a piecemeal solution. So you have some advantages. Yet on the other hand, one could say that you're in a sense rewarding member states for not complying with air quality limits. And it also goes against the constatation that local traffic really significantly can contribute to exceeding limit values in urban areas. And then a last remark, it's also a bit more legal, but it has to do with access to justice. If you apply the reasoning from our Belgian Council of State, then you don't have to take much notice of air quality considerations within spatial planning. You just have to look to the broader general measures which are being adopted. But then there is some case law which clearly indicates that whenever an inhabitant would then go to court and ask to the judge, well, review now these measures, I consider them to be inadequate, just ask, and I ask for additional measure, then there is this case, case law, for example, from the High Court of London, which clearly indicates that judges are very reluctant to do this. They don't like to review measures, general action plans, because they're not really equipped to do this. And they have the tendency to say that it's more a political question on which measures have to be taken in order to combat the increasing air pollution. As to the practical outcome of the case, the project is now partially completed. There are two victories, you could call them, for local air quality, however. One is that the city of Ghent finally concluded that it could be logical to adapt a local air quality management plan. And it did so in the year 2010, including some local traffic measures, some measures as to the construction of new parkings, but not in the middle of the city like it used to be, but at outskirts of the city, in order to enhance the use of public transport. And even more surprising is that in this local air quality management plan, the city of Ghent concluded that for the future, so not for this case study, but for future local infrastructure projects, they will really take into account these air quality considerations. So in a way, the city of Ghent conceded that perhaps it was still logical to take air quality considerations into account when in the context of spatial planning. So just 1 minute on the final conclusions and the outlook. The main overarching theme of our conference is environmental law at the crossroad. You could say that this is the case with air quality law within the European Union. As the previous speaker also mentioned, you can have perfect law. This is not the case for air quality law in the European Union. The daily limit values can be even stricter, but I mean, in essence, it's good law. But still it remains one of the most important environmental challenges for the future, because almost every member state within the European Union faces infringement actions from the European Commission for not meeting these daily limit values. However, it is also noted in the morning session, the rule of law is important for enhancing environmental protection. But in this case, it is proven that the European law is as such not really enhancing the combatement of air pollution in urban areas, because it states that because it has been concluded that it's not strict enough to say that there is a direct link between spatial planning and air quality considerations. However, to end, it is my conclusion that the integration of air quality standards in spatial planning should be enhanced. You shouldn't go that far that you should really go for a very strict approach, like stating that every project has to be really stringently tested against those air quality objectives. However, you should go to a more sustainable spatial planning, really taking into account air quality considerations. For instance, you're not going to construct a new housing zone next to a heavily polluted area in a town. So these considerations it really makes sense to take these considerations into account when planning urban development. Also, second argument is that some local traffic reduction measures, they really need a spatial translation. They need to be translated into zoning plans. For instance, one main feature of air pollution in urban areas is the fact that it stays down in these urban canyons, so between large buildings, pollution stays at street level. So you should, whenever you should in spatial planning make sure that those street canyons would be avoided to be constructed in the future. And last argument, of course, is the increasement of public acceptance of large infrastructure projects. We have one famous Belgian case also apart from this with respect to air quality. It was the construction of a new ring road across Antwerp. And it should have been a bridge, a large bridge with many tracks for a new highway. But although it had been granted a permit, it had been granted a zoning plan had been adopted, there were some NGOs who started up to protest against it, and they forced local politicians and Flemish politicians to organize a referendum. And the final outcome of the referendum was that 60% of the population of the city of Antwerp voted against the construction of this new ring road. So the project had to be aborted, and now they had to choose for a new alternative with tunnels instead of the proposed bridge. So this clearly highlights the fact that although it is not legally required, air quality considerations really have an important role to play within the context of urban spatial planning. I thank you for your attention.
Yeah, just request the presenters to come to the front. Those were very stimulating presentations that moved from almost 180 degrees. Interesting to see a bit of similarity and contrast in terms of application of the law and political decisions and the intersections back and forth, as well as the difficulty in moving away from administrative rules to ecosystem-wide rules of planning, especially in urban areas. And so I would like to welcome the audience to make comments. We have a bit of time, about 15 minutes, for questions and comments. So the floor is open.
I'm wondering if, Paul, if in looking at the Nile principles that sound very interesting, you have looked at applications to shrinking cities, which are occurring, I think, now worldwide in addition to the growing. And I know in Detroit, one of the sort of hot areas now that I've been working with is the whole role of urban agriculture in that. I just wondered if you had any thoughts about how that fit together.
Not specifically with shrinking cities, but I'd say with industries, cities where industry is in decline. because many of the areas, I mean, and specifically if you're asking about the open space links, many of the areas, urban areas that are now being looked to as potential open space, parkland, or habitat are, the large intact areas are things like former port facilities, former urban military bases, former factories, so almost brownfield sites, we might call them that loosely. Those are the types of large acreage land that is usually being looked to, and I think there's a likelihood that you'd have more of those in cities like Detroit, but that's a partial answer?
Yeah.
Okay.
We can talk more later as well.
Okay.
More questions? Sure.
I have a question for Professor Lai. If you could tell us a little bit about the NGOs in Singapore and some of the things they're doing, and then also talk about the program in Indonesia, the Name and Shame program. Is that model on the Singapore program?
Okay. The Singapore NGOs are getting, the NGO scene is getting very active now. I mean, we started first with the Solitary Nature Society, as you know, which was started by the British before the war. Now we have many local NGOs, but what's really interesting is a lot of international NGOs have come in. So we have Conservation International, we've got WWF, we've got BirdLife International, we even have the Jane Goodall Foundation now. So it's pretty active, the environment scene. Right, second question, the Proper Prokasi program. Actually, this started some years back. What happened was there was a lot of industries polluting the rivers. And the very creative government officer decided that the best thing is to have start a name and shame program. There's no point increasing fines because the place was so corrupt. So they decided to rate industries that were discharging effluent into the rivers according to a color code. Gold being the highest, best, and then I think green, and then blue, and then red and black, right? And then they got the media involved so that this was given a lot of publicity. And basically, the people, the companies who got, no company got gold. But the next grade, there were a few who got it. They got very good publicity, you know. And gradually, the other industries and factories went along with the program, and it was quite a success. Yeah. So it's just an alternative, you know, because as lawyers we always think, well, you know, let's increase the penalty, you know, and but it doesn't work that way when a country is corrupt. You just make the inspector a richer man. That's all. Yeah.
Well, the high penalty is not working. Goes hand in hand with the breakdown of the rule of law. I think in a lot of jurisdictions, in some scenarios, just not beyond natural resources, like say public vices, like smoking in public areas. You find in my country, in Kenya, the penalty for smoking in restricted areas is a maximum of $600. So obviously, you're likely to pay a bribe than pay. You know, like you don't want to go to a judge with the possibility of facing $600. So now it's getting to a point where it's becoming clear that the penalties have to go down to spot fines that are little but annoying and irritating. And so that's a key point. I think that runs across in context of administrative law.
And I think it goes back to how do you run this country, you see? You know, because the corruption comes because the government officers are poorly paid. And one of the first things the government did when they took over from the British in Singapore was to cut all salaries of civil servants. And I remember this very well. I was a little girl, and my father was a civil servant. He was an environmental engineer, actually. And then he told me, he said, I'm sorry, you have to, you know, we won't have a car fetching you to school. You have to go by bus, or you can ride a bike. and there are no more biscuits from England. And, but as soon as the economy picked up, the government restored full salaries, okay, and gradually increased the salaries of the public servants. So I think you need a government that's on the ball all the time, see. Now, of course, we think that they've gone the other extreme because they are very, very well paid, because now they are following the American system of awarding the CEOs millions of dollars. So now that, but basically, it is important to pay your civil servants well. And developing countries, the wage gap is so big, and that's why the corruption continues. Now in Singapore, we actually, if I may just continue a little bit, we actually had a Minister for National Development who was charged with corruption. And this is a very big guy, because the Ministry of National Development does all the public housing and all the redevelopment projects, and he was allegedly getting kickbacks from contractors. Then rumors started that he was building a fancy house with gold taps. Now, before anything could happen, next thing we knew, he was nabbed by the Corrupt Practices Investigation Bureau. And he was interrogated for 3 days and 3 nights. And when he was finally released and sent home, Lee Kuan Yew, our Prime Minister, first Prime Minister, visited him. Now, nobody knew what transpired between those two men, but obviously Lee Kuan Yew must have expressed his great disappointment. When Lee Kuan Yew left, the guy, this minister, took an overdose of pills and killed himself. So he was never brought to court. Nobody could say he was guilty, right? But so that was one of the biggest cases of corruption that we had. So it's not that we didn't face these issues. So the government made it very clear. In fact, in Lee Kuan Yew's memoirs, he said that the very next morning after he was elected the first Prime Minister of Singapore, he was only 32. He was a lawyer from Cambridge. He and his wife were both lawyers, first class from Cambridge. The minute he was elected, the very next morning, he called all his family together and he said, "Look here, I'm trying to run a government. I'm going to, and if I ever hear that any of you are on the take, I will not hesitate to put the full force of the law on you, because all the more reason you are my relatives, you are not supposed to be on the take." He warned them all. So in Singapore now, we have basically a very clean government. But again, recently there have been a number of cases. The top civil servants charged with corruption in rather nefarious ways, not so much in getting money because they are well paid, but giving contracts in return for sexual services. So if you Google, you see this now.
Thanks, Robert. I was meaning to ask Hendrik, what measures do you have for transboundary regulation and the control of, specifically in the European context? Because I can imagine that much of your air pollution comes from the Ruhrgebiet in Germany, which is not really your problem. Well, it becomes your problem. So,
there are no specific rules on this issue, because you do have the air quality standards. They have to be applied everywhere in the European Union, unless you can get an exemption of it, but that rarely happens. The thing is, I just think it matches a bit the numbers, because as I mentioned, in the Flemish region, we have 30 to 40% of our emissions that are really from foreign origin. Well, the particulate matter which is within our boundary is from a foreign origin. But on the other hand, you also have, for instance, a part of the Flemish pollution which is causing problems in the Netherlands and in Germany, because specifically we have more pollution from the southwest because wind blows from the southwest, so we get it from the UK and more from France, and then our problems go more to the Ruhrgebiet itself, but could be if it's very hot summer, then wind blows from the east, and then you have the other way around. But to my knowledge, there are no specific rules on that. The only thing that could work is getting really an exemption of the application of the daily limit values, and then you have to draw up an action plan, and you could include in this action plan, you could state there, well, this is a specific situation, we only can influence with our policy a certain 30 to 40% of the pollution, because all the other pollution is coming from another country. So you can argue then that you, in your own region, you get an exemption of the application of the daily limit values. And then on the other hand, of course, the other country also has to apply strict rules for its industrial installations and for its cars. So you have those general European rules which have to be respected at any point in any time. But you don't have specific rules which deal with that problem. I guess also because it can really change from one year to another. I mean, you can have a cold winter with winds from the east, and you have more German pollution in Belgium. You get you can have quite a wet summer with more southwest winds, and then you have more pollution from France and the UK. So I guess this could explain why there are no specific rules.
Thank you.
I think what is interesting is the intersection between two key points. What they're saying is that the administrative boundaries, the laws from different jurisdictions trying to deal with a problem that has absolutely no respect across jurisdictions. And what was going through my mind as he spoke is the variances in nature at different seasons, whether the science changes and renders the law almost inoperative.
Well, it kind of brings us back to a point that was made in a couple of presentations, is that even at the EU level, which, I mean, you are renowned for your excellent environmental laws, there's not really a recognition for this ecosystem approach to environmental governance, or to this more integrated approach to the bigger environmental problem as such. Robert also says.
Yeah, you do have, of course, also a European directive with respect to environmental impact assessment. So this also includes the effects on air quality. But then again, in this specific case I mentioned, there was a complaint at European level. So you can issue a complaint at the European Commission. And there were two arguments. First argument was, the air quality directive is not respected. But then the Commission just stated, well, there's no specific clause in the air quality directive, so it's not violated. And second argument was then, but the impact assessment really indicated that there was a trouble with respect to air quality, and you have also a European directive with respect to environmental impact assessment. But then the Commission stated, well, but in this, there is a specific clause, but it just states that you have to take into account literally the results of the environmental impact assessment, which is totally different from, for instance, other provisions in European law with respect to nature conservation, when it clearly states when you have a negative outcome, you can't get a permit for a project. But this is not generally the case. So I guess air pollution is a good example of, like you also mentioned, you can have ideal rules, but I mean, it's a perfect example of how Europe is really having troubles with enforcing those rules. Well, because the only thing you can do is just go to the Commission, issue a complaint, and the Commission could then start a procedure against the member state. But then again, a member state, you can't change these issues in 1 or 2 years. So then you have a fine, and then nothing has changed in practice, but you do have a fine.
Thanks.
I had a question which I'll put to Hendrik. I was curious, as you're talking about the link between air pollution and land use zoning approvals, whether the concept of mitigation or offsets has come into play. And why I'm asking is, at least in California, we have an environmental impact assessment law called CEQA, California Environmental Quality Act, and increasingly the way it's developing is that if you're going to have a land use approval that's going to increase, let's say, greenhouse gases or air pollution, you need to identify ways to mitigate that down to offset it. So you can do the project, but that means you might need to fund some other project or some other improvement to mitigate it, which is a way that people can go. As long as there are mechanisms in place for the offset, they still get to go forward, but only if they can sort of come up with a carbon neutral mitigation scheme. So I don't know if it's not working that as well as I just described, by the way. But that's the theory.
That's of course. Well, I could reply to that. That also a bit discussed this Dutch situation. They were the most strict country with respect to air quality legislation, and they were the only country that really read the directive and thought, well, how should we now implement it? Okay, we're gonna take the air quality objectives as a criteria when issuing permits. But then, yeah, they faced the problem that, yeah, of course, you have negative effects, but then there is only one option, just refusing the permit. So they first introduced a kind of offsetting scheme in order to allow spatial development to a bit coincide with air quality management. And then you had to prove that whenever you have a negative outcome at one specific site, that the project could have a positive outcome, for instance, on another site. This was also one of the arguments in the specific case I mentioned. The project developers stated, well, yeah, of course we're going to have a negative outcome in the immediate surroundings of the railway station due to the car park and the new access road. But because we're also renewing the railway station, more people are going to take the train, so we have a positive outcome in general. But the Belgian Council of State just didn't go into that argumentation, just stated there is no link. And also in the Netherlands, because it appeared that they were the most strict country, they just decided after this offsetting regime to just say, well, nobody really requires it because the European Commission is just adopting a more lenient approach, so why should we even have it? And they just abolished it and now have an even more lenient approach.
I also think it, even conceptually, because it's not really working the way it's going, it works better with something like greenhouse gas emissions than particulate matter, because the impacts of particulate matter, it's the same debate about cap and trade, are so localized that if you have certain populations where there's clusters of heavy particulate emissions, they just keep getting burdened with them. So there's equity implications that need to be thought about.
I'm just wondering, Hendrik, whether or not that also, the fact that the government, the authorities did not recognize the arguments of people, is it because of a lack of awareness? Well, sometimes these people in charge, they have a very narrow education, and there's a need, because environmental issues are well, they are fairly new, it's 20 years. And I mean, we are all lawyers here, but I always feel, I come from a family of engineers. They tend to be very narrow. And these people, the people who are enforcing these laws, basically they are engineers. They are people with a science background that don't see beyond very small, limited vision, basically.
Yeah, that could be true for the Flemish case, because you have different administrative authorities. You have one for urban planning, you have one for environmental policy. So this is already a start of the problem.
Yeah. So I think that's usually the challenge of bureaucracy. You can't have all lawyers enforcing the laws. Quite often it's difficult. Administrative law will be enforced by an engineer who thinks some of the procedures are obstacles. On the other hand, the laws sometimes seem to slow down what to do, and I'm not entirely sure any legal system has figured out what to do with that. Yeah, I think that we've pretty much exhausted the time allocated. Thank you very much, and I would request a round of applause.